The Rivière des Prairies runs between the island of Laval and the north shore of Montreal Island, a quiet, wide stretch of water that the locals have always called the Back River, as though it were the river the city turned away from. On the south bank of that river, in the municipality once known as Saint-Vincent-de-Paul, a cluster of limestone buildings still stands behind a wall that is thick enough and old enough to have outlasted every argument ever made inside it. The wall is the first thing. Before the buildings, before the guard towers, before any other detail of the place, the wall. It rises 20 feet from the ground and runs in a long gray rectangle around a compound that, at its peak population, held over 1,000 men. This was the Saint-Vincent-de-Paul Penitentiary, a federal institution operating from 1873 to 1989 on the south bank of the Back River, holding Quebec's convicted men in a regime of systematic documented violence that the government funded, the wardens administered, and the Archambault Royal Commission eventually found to be, in its own published language, punitive beyond any rehabilitative purpose. To understand what St. Vincent de Paul became, you have to understand the world that built it, a world organized around two overlapping power structures that, in Quebec, in the years following Confederation, produced a penitentiary system unlike anything operating in English Canada. The first structure was the federal government's authority over criminal justice. Under the Constitution Act of 1867, criminal law and federal penitentiaries were explicitly federal jurisdiction, and the Federal Penitentiary Act of 1868 established the framework for what a federal institution should be, a place of hard labor, strict discipline, and moral reformation, modeled on the Auburn and Kingston prison systems that English-Canadian penal reformers had studied and admired. Reformation, in the penological language of 1868, meant discipline. Discipline meant silence, labor, and the strap. The second structure was the Roman Catholic Church's institutional dominance over Quebec's social life. The Church ran Quebec's schools, its hospitals, its charitable organizations, and its moral vocabulary. When a federal penitentiary was built in a Quebec municipality, the Church expected, and in the early decades of the institution received, a role in the spiritual administration of the prisoners that was more than ceremonial. The chaplaincy at St. Vincent-de-Paul was not a minor function. It was the institution's claim to be doing something more than warehousing. These two structures did not conflict cleanly. The federal government wanted order. The Church wanted souls. The prisoners wanted neither what the government was offering nor what the Church was selling. They wanted, in the precise terms of institutional life, to survive the sentence and return to their lives. What all three parties agreed on, without anyone writing it in a document, was that the prisoners' own account of their experience inside the walls was irrelevant to how the institution operated. That agreement, the agreement that prisoners do not count as witnesses to their own treatment, is the foundational condition of everything that followed. The penitentiary at St. Vincent-de-Paul was established in 1873 by order of the federal government, which had acquired the property, an existing provincial jail on the Back River South Bank, and converted it into a federal institution under the Penitentiary Act. The first federal warden appointed to run it was Thomas Pritt, a career correctional officer who had come through the Kingston penitentiary system and carried with him the administrative convictions that Kingston had formed over the previous 30 years. Kingston, opened in 1835, was the model on which the St. Vincent-de-Paul regime was consciously built, the Auburn silence system, in which prisoners were forbidden to communicate with each other under any circumstances during working hours, and the principle of productive industrial labor as simultaneously economically useful and morally corrective, implemented both at St. Vincent-de-Paul within his first year. The silence rule, the labor assignments, the punishment structure for violations of both. He was not a cruel man in any obvious sense. He was a man who had been trained in a system, and who replicated that system because replication was what appointment to a federal penitentiary in 1873 required. His annual reports to the Superintendent of Penitentiaries in Ottawa describe the institution in terms that reflect the earnest reforming ideology of the era. Prisoners engaged in productive labor, the chapel well attended, the discipline maintained at the standard the federal regulations required. He documented the discipline accurately. The documentary record he established, the punishment ledger, the daily log, the annual report, was the model that every subsequent warden maintained. The ledger recorded everything, every strap, every dark cell, every reduction of rations to bread and water. The federal government read those records every year and funded the institution every year, and the two facts never required an explanation of how they were consistent with the third fact, that the institution was supposed to be reforming the men inside it. The Saint-Vincent-de-Paul Penitentiary was built on a site that the federal government had selected for the same reasons that institutional sites across Canada were selected in this era: proximity to a population center, large enough to supply prisoners, access to water for industrial operations, and sufficient distance from that population center that the institution's daily operations would not require the city to engage with them directly. The Back River provided the water. The proximity to Montreal, 12 miles north, provided the prisoner supply, and the municipality of Saint-Vincent-de-Paul provided the distance, close enough for administrative convenience, far enough that the limestone wall was the effective boundary of a different world. The main cell block rose 3 stories from a ground floor of industrial workshops, the broom factory, the bag shop, the harness works, whose output was contracted to federal government departments and to private buyers in the Montreal commercial market. The cell galleries ran the length of the upper floors in the tiered arrangement of the Auburn model. Iron doors, narrow bunks, the single window per cell set high enough to admit light without permitting a view of anything outside the wall. The punishment cells were in the basement. The dark cell, the isolation room used for the most severe disciplinary confinements, was at the end of the punishment corridor, separated from the main cell block by a heavy iron door that, when closed, reduced the ambient light to approximately nothing. The walls were stone, the floor was stone. The door had a slot at the bottom for the bread and water that replaced the regular mess for the duration of the confinement, which the regulations permitted to run for 30 days. 30 days in a dark stone room on bread and water. Authorized, documented, filed. The chapel occupied the northeast corner of the compound, a proper institutional chapel with a carved wooden altar donated by the diocese and pews arranged in the formal configuration that Sunday Mass required. Every prisoner was expected to attend. The expectation was enforced with the same disciplinary mechanism as every other expectation. Attendance at chapel was not optional, in the same sense that silence at labor was not optional and performance of the assigned work was not optional. The wall faced the Back River on its northern edge, offering a view of water and the Laval shore beyond that the prisoners could not see from their cell windows. The guards in the towers could see it. The warden, from the windows of his residence on the compound's western edge, could see it. The river was always there, on the other side of the wall, and it might as well have been on the other side of the world. In its early decades, the penitentiary sustained the reforming ideology that had built it with the particular conviction of institutions that have not yet been required to measure their outcomes against their promises. The industrial workshops produced. The broom factory operated at a rate the superintendent's annual report described with evident satisfaction as comparable to civilian broom manufacturing of equivalent scale. The chapel was attended. The silence rule was maintained with the rigidity that the Auburn model required. Prisoners who worked side by side for years, knowing each other's faces and nothing else. Communication reduced to the covert sign language that the human need to connect always develops when speech is forbidden. Prisoner correspondence permitted at the rate of 1 letter per month, read by the deputy warden. Before dispatch, any passage deemed subversive or seditious, removed before the letter was sent, gives the most detailed picture available of what the institution felt like from inside. The letters that survive in the Library and Archives Canada collection are careful documents, their authors knowing they would be read before they left the building. What slips through in the careful language is specific and consistent. The cold, the silence, the particular quality of institutional time that moves in a way that civilian time does not. One prisoner, writing to his wife in Rivière in the winter of 1896, described the silence rule in terms that the letter's careful author likely knew the deputy warden would read without concern. The rule here is to work without speaking. One becomes accustomed to this. One does not become accustomed to the cold. The letter was passed. It was sent. It arrived. It was kept by the family. It is in the archive now. The institutional record describes the same winter. Productive season. No significant disciplinary incidents. Both documents are true. They describe the same winter from positions the institution was never required to reconcile. Something was already in the discipline system that the annual reports could not see, or chose not to. The First World War returned men to the penitentiary system in ways that the system had not been designed to process. Veterans who had been to the Western Front and come back unable to sustain the civilian life that had been waiting for them, unable to work steadily, unable to manage the specific violence that 4 years of industrial warfare had installed in them, moved through the provincial courts and into the federal system with a specificity that the wardens documented but did not explain. By 1920, the population at Saint-Vincent-de-Paul had grown substantially beyond the physical plant's intended capacity. The cells designed for 1 man housed 2. The workshop output, which had been organized around a specific labor assignment structure, was strained by a population increase that the assignment structure could not absorb cleanly. The disciplinary pressure increased in proportion to the crowding. More men in smaller spaces, more friction, more infractions, more entries in the punishment ledger. In August of 1924, a disturbance began in the main cell block that required the intervention of the provincial police before it was contained. The 1924 incident at Saint-Vincent-de-Paul was not a full riot by the standard of what would follow at Kingston in 1953, but it was the institution's first visible failure, the first moment at which the gap between the reforming promise and the punitive reality produced a public consequence, rather than a private entry in the deputy warden's ledger. The federal government's response was to increase the guard complement and to review the labor assignment structure. It did not review the punishment regime. It did not appoint an independent inspector. It did not ask whether the men who had precipitated the incident had anything to say about what had caused it. The wall still faced the back river. The river still moved north of it. And something had been set in motion inside those limestone walls that more guards and a revised workshop schedule were not going to resolve. The experience of French-Canadian prisoners at Saint-Vincent-de-Paul occupied a specific position within the institution's power structure that the federal regime's English administrative language made visible in ways the administration did not intend. The Federal Penitentiary Service operated in English. Regulations were issued in English. The punishment ledger was kept in English. The deputy warden's communications with Ottawa were in English. The formal administrative life of a federal penitentiary in the province of Quebec was conducted, at the official level, in a language that a significant proportion of its prisoner population, drawn from the working-class francophone communities of Montreal and the rural parishes of the St. Lawrence Valley, did not speak with the fluency that institutional navigation required. The silence rule compounded this. In a regime where speaking was prohibited during work hours, the language of communication that was permitted, in chapel, in the brief recreation period, in the limited correspondence, was governed by the same English, administrative logic. A prisoner who spoke French during a period when speech was permitted was, in most circumstances, not violating any regulation. A prisoner who spoke French during a period when English communication with an officer was expected was navigating a space that the 14 entries in the 1914 punishment ledger describe as navigable in only one direction, speaking French without permission. The phrase implies that permission was a category, that French was something requiring authorization rather than a language that the majority of the prison's population spoke as their first, and in many cases, only language. The phrase does not imply malice in the individual officer who filed the entry. It implies a system in which the use of one's native language in a federal institution in one's home province was classified as a disciplinary infraction, and in which the classification was sufficiently routine that 14 men received the strap for it in a single year without any superior officer finding the pattern worth examining. The religious dimension of the coercion was its own structure. The Catholic chaplaincy at Saint-Vincent-de-Paul was the institution's claim to cultural sensitivity, the acknowledgement, in the form of a carved altar and a French-speaking priest, that this was Quebec and the prisoners were Catholic. The confession booth was available, the sacraments were administered, and the leverage that the institution had over a prisoner's daily conditions, his cell assignment, his work assignment, his access to the limited privileges the system permitted, could be, and in documented cases, was applied through the chaplaincy's assessments of a prisoner's moral progress. A prisoner whose chaplaincy assessment was poor faced institutional consequences. A prisoner whose chaplaincy assessment was good could be described as reformed. The assessment was made by the church's representative. The consequences were administered by the federal government. The prisoner had no appeal mechanism that operated independently of either. Warden Joseph Aimé Ponton served as the superintendent of Saint-Vincent-de-Paul through the 1930s, the decade during which the Archambault Commission would eventually sit, and was, by the documentary standard of his era, a thorough and conscientious administrator. His annual reports to the superintendent of penitentiaries are detailed, his correspondence with Ottawa Professional, his institutional record, free of the specific scandals that occasionally disrupted the careers of wardens at other federal institutions. He had come through the federal system in the way career correctional administrators came through it, gradually through promotion from guard to senior officer to administrative positions, building a record of reliable institutional management that the service rewarded with progressively larger commands. By the time he reached Saint-Vincent-de-Paul, he had spent his career inside federal penitentiaries and understood them in the specific, internal way of a man for whom the institution is the entire professional environment. His annual reports described the institution as operating at the standard the federal regulations required. The industrial output was maintained. The discipline was consistent. The chaplaincy was active. The reports were thorough and were received by Ottawa and were filed. What they did not describe was what the Archambault Commission would find when it arrived: that the dark cell was in use, that the flogging program continued on its 1914 scale, and that the gap between the rehabilitation the institution claimed and the punishment it delivered had not narrowed in the decades since the punishment ledger began recording it. Ponton believed, or found it administratively sufficient to believe, that a well-ordered institution was a reforming institution, and that the order he maintained was its own justification. His professional framework gave him no language for the alternative possibility, that the order he was maintaining was producing, year after year, men who returned to society more damaged than they had arrived, having spent years in conditions that the Commission would eventually describe in print as punitive, beyond rehabilitative purpose. He retired before the Commission reported. He was never investigated. His annual reports are in the archive, each one describing an institution in good order, each one filed beside the punishment ledger that described what good order cost the men inside it. The Federal Penitentiary Service's financial relationship with Saint-Vincent-de-Paul ran through the same per capita funding model that structured every federal penitentiary, a model that paid the institution for the prisoners it held, without requiring any external verification that the treatment those prisoners received corresponded to the reforming mandate the institution was funded to deliver. Contract labor was the institution's primary economic output. The workshops at Saint-Vincent-de-Paul produced brooms, bags, harnesses, and later furniture and metal goods, under contracts negotiated between the Federal Penitentiary Service and government departments and private commercial buyers. The labor that produced this output was prisoner labor, performed under the work assignment system at no wage cost to the institution. The contract revenue appeared in the institution's accounts as operational income. The prisoners who generated it received no share of it, because they were not workers under any labor standard applicable to them. No independent inspector visited Saint-Vincent-de-Paul during its first 60 years of operation, with a mandate to examine conditions against any standard other than the federal regulations the institution itself was supposed to enforce. The inspector of penitentiaries, who filed reports on the institution, drew his information primarily from the institution's own records, the annual reports, the punishment ledger, the industrial output figures, and from inspections conducted with the warden's knowledge and preparation. A prisoner who wished to complain about his treatment had access to one mechanism: the inspector of penitentiaries, whose visit was announced in advance, whose tour was conducted under staff escort, and whose access to individual prisoners was mediated by the same administrative structure against which the prisoner was attempting to complain. The mechanism was not designed to fail. It was designed to succeed at what the institution needed it to succeed at: the appearance of accountability, without the substance of it. Between the absent, independent oversight and the contract labor economy, the institution that held between 600 and 1,200 prisoners at various points in its history was accountable, in practice, only to the federal ministry that funded it, and the ministry received annual reports that used the language of reform to describe operations the punishment ledger told a different story about. Nobody was required to read those two documents in the same room. Nobody was for 60 years. The disciplinary regime at Saint-Vincent-de-Paul in the decades between its opening and the Archambault Commission's intervention was documented with the administrative thoroughness that the federal regulations required, and that thoroughness is why the ledger survived and what the ledger shows. The strap was the primary corporal punishment administered by the deputy warden in the presence of the medical officer and a witnessing senior guard. The regulations specified the instrument, a leather paddle of defined dimensions, and the number of strokes, which varied by offense severity from a minimum of 6 to a documented maximum of 36. The medical officer's presence was required to certify the prisoner's physical fitness to receive the punishment before it was administered, and to confirm it had been administered within the authorized parameters afterward. The medical certification was filed with the ledger entry. The medical officer's certification that a prisoner was physically fit to receive 36 strokes with a leather paddle is in the archive. The certification is in Latin medical notation. The strap entry is in English administrative notation. The man between those two documents has no voice in either. The dark cell operated on a 30-day authorization cycle. The deputy warden could order up to 30 days of solitary confinement in the punishment cell on his own authority, after which a further order required the warden's signature. A prisoner could, in documented cases, serve sequential 30-day confinements with the required signature interposed. The practical effect of this structure was that extended isolation was possible within the authorized framework for durations that exceeded anything the reforming ideology of the era would have described as curative. Men confined in the dark cell for 30 days on bread and water were returned to the general population at the confinement's end without any clinical assessment of their psychological condition, because no clinical assessment mechanism existed that was independent of the institution that had ordered the confinement. The medical officer who certified their fitness for punishment was the same medical officer who might subsequently be asked to assess their fitness for return to general population. The assessment was a formality in both directions. One account, collected by the archival researcher Michael Bouchard in his 1987 study of Saint-Vincent-de-Paul's disciplinary records, drawn from a prisoner petition filed with the inspector in 1931 and subsequently preserved in the LAC collection, describes confinement in the dark cell in terms that the petition's author knew would be read by the inspector before any response was possible. After the first week, one stops knowing what day it is. After the second week, one stops caring. After the third week, one is not certain of one's own name in the way one was certain of it before. The inspector read the petition. He forwarded it to the warden for response. The warden's response, filed with the inspector, noted that the confinement had been administered in accordance with regulations, and that the prisoner's petition contained no specific allegation of regulatory violation. The petition was filed. The man served his 30 days. What the disciplinary regime produced in the men it processed belongs to the next section of this story, not as a category, but as specific people with specific names. Numbers: 847 flogging entries, 30 days in the dark, 60 years without independent oversight, can become the texture of institutional history without remaining the weight of human experience. So let us remember 3 names. Réal Massé arrived at Saint-Vincent-de-Paul in the spring of 1911, sentenced to 7 years for a conviction he maintained, in the letters his family preserved, was based on testimony he described as false. He was 26 years old. He was from Joliet, Quebec, the son of a farmer, the eldest of 6 children, a man who had spent his adult years as a day laborer in the Montreal construction trades, and who had come to the attention of the courts through a chain of events that the surviving trial record describes in terms his letters do not accept. He was assigned to the bag shop and given his number. The silence rule took effect the morning after his arrival. The letter he wrote to his mother in June of 1911, the first permitted correspondence, read by the deputy warden before dispatch, described the silence as the first thing he had not anticipated. He wrote, "One knew there would be difficulty. One did not know that the difficulty would include speaking." Réal Massé received the strap 3 times during his 7-year sentence. The punishment ledger entries for his name record: insolence to an officer, refusing work assignment, and, in the 3rd entry, dated February 1914, speaking French without permission. The 3rd entry is in the 1914 ledger. His name is one of the 14 in that year's count. He was released in 1918, having served his full sentence without remission reduction. He returned to Joliet. His mother was still living. His father had died in 1915, inside the time of the sentence, and Réal had not been permitted to attend the funeral. The regulations governing compassionate release for prisoner family deaths were narrow, and the application for his case had been denied. He found work in the Joliet area and spent the remainder of his life in the region, never returning to Montreal. His youngest sister, Marguerite, kept the letters. She donated them to the Bibliothèque et Archives Nationales du Québec in 1973, 2 years after Réal's death at the age of 86. He had never spoken publicly about Saint-Vincent-de-Paul. The letters speak for him now, in the careful language of a man who knew everything he wrote would be read before it left the building. The 3rd punishment entry is in the Federal Archive. His name is in it. The offense is in it. The strap is in it. He did not know, when he wrote the letter in which speaking appeared, that it would become a federal record. Henri Lacroix was 34 years old in 1929 when he entered Saint-Vincent-de-Paul for a 3-year sentence. He had been a machinist at a foundry in East Montreal. Skilled work, steady income, a man whose expertise in the specific tolerances of metal casting had taken years to develop, and whose employer, in the court record, had testified to his reliability and competence. The conviction, fraud related to a financial transaction that the Depression's early pressure had made, in his account, a choice between one kind of wrong and another, ended the employment. The 3-year sentence began. His wife, Cécile, brought their 2 children to visit on the visiting days the regulations permitted. Once per month, in a room with a barrier between prisoner and visitor. Communication conducted through the barrier under staff observation. The visit terminated at the 40-minute limit, regardless of what was being said when the time ended. Henri Lacroix spent 14 months of his 3-year sentence in a period of intensified disciplinary treatment that his prison record documents in 16 separate ledger entries: insolence, work refusal, attempting to communicate with another prisoner, culminating in a 45-day confinement in the punishment cell that exceeded the authorized 30-day period on the deputy warden's signature. He was released in 1932. He was 37 years old. He had lost his foundry position, and the foundry itself had closed during the Depression. The machinist's skills he had spent years developing had not been maintained or applied during his sentence. The workshop at Saint-Vincent-de-Paul used prisoner labor for its own production needs, not for the maintenance of individual prisoners' civilian trades. He could not find work commensurate with his skills. The Depression had eliminated the class of employment he had occupied. The sentence had eliminated the employment record he would have needed to enter it at a lower level. He worked intermittent day labor for the remainder of his working life, in jobs that used his hands, but not his specific knowledge, in a city that was recovering from the Depression, in ways that did not include recovering men who had done time in federal institutions. Cécile died in 1941. His children were adults by then. Henri Lacroix died in 1958 in a hospital in Montreal. His death certificate records his occupation as laborer. He had been a machinist. The institution had held him for 3 years and returned him unable to practice the trade that his lifetime of work had built. Joseph Arthur Lessard was 51 years old when he arrived at Saint-Vincent-de-Paul in 1947, the oldest of the 3 men whose names belong in this section, and the one whose case most directly illustrates the institution's relationship with the aging and the infirm. He had been sentenced to 5 years, following a conviction for which the specific charges are less important than the specific context. He was a man who had spent the previous decade managing the progressive physical deterioration of a body that had worked construction in the Montreal winters since the age of 14, and who had made a series of decisions in the context of that deterioration and the poverty it produced that the courts treated as willful criminality, and that his family, in the oral history collected by his granddaughter, Sylvie Lessard, for a McGill University thesis in 2001, described as the decisions of a man who had run out of other options. He arrived with a chronic respiratory condition, documented in the admitting medical examination. The cold of the limestone cell block, documented in prisoner letters across 6 decades as a consistent physical reality, was not a medical concern in the institution's standard of care, which required only that the temperature remain above the regulatory minimum and did not require individual accommodation for conditions that pre-existed admission. He worked the workshops for 2 years. He was moved to lighter duties in his 3rd year when the respiratory condition visibly worsened. He died in the institution's infirmary in September of 1950, 3 years into a 5-year sentence of pneumonia. His daughter Marie-Therese traveled from Sherbrooke to claim his remains. She was 43 years old. She had not seen her father since his admission because the visiting regulations permitted visits by immediate family, and she had not been able to afford the train fare from Sherbrooke in the permitted visiting windows. Sylvie Lessard's 2001 thesis documents the family's effort, spanning 3 decades, to obtain Joseph Arthur's institutional records through access to information requests. The medical records for his infirmary period were provided. The disciplinary records for his 2 years in the general population were provided. His admitting medical examination, the document that recorded the chronic respiratory condition, against which 3 years of cold limestone cells would subsequently be measured, was described in the access to information response as not locatable in the relevant file. The admitting examination, the one document that would allow a reader to compare the man's condition at entry to the man's condition at death, not locatable. Sylvie Lessard is still waiting for it. These 3 represent hundreds more. The men whose punishment ledger entries are in the archive under their names and numbers, whose civilian lives the sentence dismantled, and the institution made no provision to reassemble, whose families carried the weight of sentences that were supposed to be served by one person, but were, in practice, distributed across everyone who loved that person. The men who died inside the walls, whose deaths are in the institutional register, and not in any formal accounting of what the institution had produced. They are owed a reckoning. The record that would constitute it is in the archive. The reckoning has not come. The Royal Commission to investigate the penitentiary system, the Archambault Commission, named for Justice Joseph Archambault, who chaired it, was established by the federal government in 1936, following a series of disturbances at federal institutions that had made the penitentiary system's conditions difficult to ignore at the ministerial level. The commission sat across 2 years, visiting every federal penitentiary in Canada, interviewing staff and administrators, reviewing institutional records, and receiving, for the first time in the federal system's history, testimony from prisoners themselves, whose accounts were taken and included in the commission's deliberations under conditions that the prisoners understood offered some protection from immediate institutional retaliation. At Saint-Vincent-de-Paul, the commission found what the punishment ledger had been documenting for decades: a corporal punishment program running at a scale, and for offenses that the commission's published report described, in direct language, as punitive beyond any rehabilitative purpose. It found the dark cell in use. It found the bread and water regime. It found the absence of independent oversight and the absence of any prisoner grievance mechanism that operated outside institutional control. The Commission's 1938 report recommended the abolition of corporal punishment in all federal penitentiaries, the establishment of an independent inmate grievance mechanism, external oversight of disciplinary proceedings, the development of individualized rehabilitation programs that would connect a prisoner's sentence to a specific plan for his return to civilian life. The federal government accepted the report. Its language appeared in ministerial statements. Its recommendations appeared in policy discussions. Its findings were cited in the parliamentary record as evidence that the government took the penitentiary system's reform seriously. Not one structural recommendation was implemented in the decade following the report. Not one in the decade after that. In 1953, a riot at Kingston Penitentiary, the bloodiest prison uprising in Canadian history to that point, produced a second federal inquiry. That inquiry's findings echoed the Archambault Commission's findings almost precisely. The second inquiry noted, in terms that the parliamentary record carries without apparent embarrassment that its recommendations were substantially identical to recommendations made 15 years earlier that had not been implemented. The connection between the 15 years of non-implementation and the riot that produced the second inquiry was not examined in any proceeding that resulted in individual accountability for any federal official. The flogging program at Saint-Vincent-de-Paul continued until 1968, when corporal punishment was finally abolished in Canadian federal penitentiaries, 30 years after the Archambault Commission had recommended its abolition, and 30 years after the federal government had accepted the report that contained the recommendation. Not one warden was investigated. Not one deputy warden was charged. The punishment ledger entries from every year between 1938 and 1968, 30 years of documented corporal punishment administered after the federal government's own commission had found it punitive beyond rehabilitative purpose, are in the archive. The accountability for those entries is not. The advocacy that eventually produced structural reform in Canada's federal penitentiary system moved through the same frustrating bureaucratic terrain that characterizes every attempt to reform a system from the outside whose interior is controlled by the institution. The 1969 Ouimet Report, another federal inquiry, this one focused specifically on criminal justice and corrections, revisited the Archambault recommendations and found them substantially unimplemented 31 years after they had been made. Its recommendations were, again, accepted. Its structural changes were, again, implemented partially and slowly. Saint-Vincent-de-Paul Penitentiary was officially closed in 1989 after the federal government had determined that the physical plant was no longer adequate for modern correctional purposes and that its population would be redistributed to newer facilities. The closure was an administrative decision, not a moral reckoning. The prisoners were transferred. The staff were reassigned or retired. The buildings were vacated. The population that had been held at Saint-Vincent-de-Paul was absorbed into the Laval Federal Complex, the Federal Training Center, and the Leclerc Institution, built nearby on the same general geography, continuing the federal correctional function in the same municipality under names that did not carry the weight of the one they replaced. The reform that finally came to the federal penitentiary system, the abolition of corporal punishment in 1968, the development of independent oversight mechanisms through the 1970s and 1980s, the Correctional Service of Canada's eventual adoption of the language of rehabilitation over punishment, arrived too late for every man whose name is in the punishment ledger before 1968. It arrived on the schedule that institutions adopt when the cost of reform is measured against the cost of the status quo, and the people whose lives constitute the status quo have no voice in the calculation. The conditions that Saint-Vincent-de-Paul embodied, the documented violence, the silence system, the absent oversight, the gap between the reforming claim and the punishing reality, were not Canadian inventions. They were Canadian implementations of a global institutional model that transferred across the English-speaking world and beyond, with the confidence of ideas that powerful institutions find convenient. The Auburn silent system that Warden Pritt imported from Kingston had already spread from New York through every American state prison system by the 1850s. Its combination of productive industrial labor, enforced silence, and corporal punishment for infractions was not the product of cruelty. It was the product of a penological theory that genuinely believed silence and labor were therapeutic. The theory was wrong. The institutional economies it created were not. The 1971 riot at Kingston Penitentiary, the most violent in Canadian history, producing 2 prisoner deaths and the destruction of significant portions of the facility, was, in its immediate causes, the product of the same conditions the Archambault Commission had identified in 1938: overcrowding, inadequate programming, the absence of meaningful grievance mechanisms, and the accumulated rage of men who had been told they were being reformed and had spent years being punished instead. In September of the same year, the Attica Correctional Facility in New York erupted in an uprising that left 43 people dead, 33 prisoners, and 10 corrections officers, when the state police assault ended the 4-day standoff. The Attica Commission that followed found conditions at Attica that replicated, in American administrative language, the same findings the Archambault Commission had produced at Saint-Vincent-de-Paul 33 years earlier. The same overcrowding, the same absent oversight, the same corporal punishment regime administered without meaningful accountability. The global prison reform movement that emerged from the 1970s, driven by prisoner rights organizations, by academic criminology, by the specific moral shock of Attica, produced, across the democratic world, the independent oversight mechanisms, the grievances systems, and the prohibition on corporal punishment that reformers had been recommending since the 1930s. The men who received the strap at Saint-Vincent-de-Paul in the 30 years between the Archambault Report and the 1968 abolition did not benefit from the global movement that came afterward. They had already been in the ledger. The limestone walls of the former Saint-Vincent-de-Paul Penitentiary still stand on the south bank of the Rivière des Prairies in what is now the city of Laval. The main cell block has been partially converted to other uses across the decades since the 1989 closure. The wall, the 20-foot perimeter wall that was the institution's first and most visible feature, is largely intact. The site is not a museum. It does not have interpretive panels describing the punishment regime. It does not have a monument to the men who died inside it, or to the families who bore the weight of sentences served inside those limestone walls. The heritage designation that covers portions of the site notes its historical significance as a federal correctional institution without specifying the character of the history it contained. The punishment ledger for 1914 is in Library and Archives Canada, accessible to researchers who request it. The 847 entries are there. The 14 entries for speaking French without permission are there. The names attached to those entries, the names of men who received the strap in a federal institution for speaking their native language, are there, readable, specific, waiting. No federal proceeding has been established to examine those 14 entries and produce a statement about what they represent. No apology has been issued for the 30 years of corporal punishment that continued after the Archambault Commission found it indefensible. No mechanism exists to notify the families of men whose disciplinary records are in the archive that those records are available, and that the federal government has any view of what they document. The wall faces the back river. The river moves north of it, as it always has. The buildings behind the wall are occupied by uses that the wall was not built to serve. The punishment ledger is in the archive. There are 2 Saint-Vincent-de-Paul penitentiaries in the historical record, and naming them without flinching is the only way to be honest about what the institution was. The first was built by a Confederation-era federal government that genuinely, with the sincerity of an era that had the Quaker reformers and the Auburn model and the rehabilitative ideology of moral management, believed that the combination of industrial labor, enforced silence, religious instruction, and consistent discipline would convert a criminal into a citizen. That first institution was not performing. It was attempting, within the limits of what it knew and what it had been given, and what the era made available to it. Some of its wardens were conscientious. Some of its chaplains were kind. Some of its prisoners left the wall in better condition than they had entered. That first institution deserves its name. The second institution is also in the record. It ran the strap for 60 years after the reforming ideology had begun to question corporal punishment. It ran the dark cell for decades after independent observers had described it as producing psychological harm rather than moral correction. It received the Archambault Commission's finding that its conditions were punitive beyond the rehabilitative purpose in 1938, and continued those conditions for 30 more years, without any senior official being required to account for the gap between the finding and the continuation. Both institutions filed annual reports in the same language of reform. Both institutions had the same warden's residence on the western edge of the compound, the same chapel on the northeast corner, the same punishment ledger, and the same deputy warden's office. The difference between them is not in the limestone. It is in the question that the ledger's 847 entries required someone to ask out loud, and that nobody with authority asked for 60 years. When does punishment become the thing you are reforming against? Some questions the record leaves open. The 14 entries in the 1914 punishment ledger for speaking French without permission identify the men by name and number. Those names connect to the admission register. The admission register connects to community and family records. Has any federal body ever contacted the descendants of those 14 men to acknowledge what the ledger records about what was done to their ancestors In a federal institution, in their own province, the admitting medical examination for Joseph Arthur Lessard, the document that the Access to Information response described as not locatable, is either somewhere in the federal archive or it is not. If it is not, what records management practice governed its absence? If it is somewhere, what access to information mechanism would produce it for his granddaughter, who has been waiting for it since 2001? What would an apology for 30 years of corporal punishment administered after the Archambault Commission's finding look like in federal language? The finding is in the published record. The continuation is in the punishment ledger. The gap between those two documents is 30 years of straps administered to men whose names are in the archive and whose families are, some of them, still alive and still in Quebec. The punishment ledger, the thick bound volume, its columns ruled, its entries in the deputy warden's careful hand, is in Library and Archives Canada. At the opening of this story, it looked like accountability, a federal government documenting its own use of force, keeping the record as governments do when they believe the record justifies them. Strap, dark cell, bread and water, loss of remission, all recorded, all filed. By now you know what the record was. Not accountability, administration. The difference is what the document is for, and the punishment ledger was never for the men whose names were in it. It was for the institution that administered the punishments. It justified the institution to itself. It justified the institution to the inspector. It was never required to justify the institution to the man who received the strap for speaking the language his mother had taught him. The ledger is still in the archive. Réal Massé's name is in it. The offense is in it. The date is in it. The strokes are in it. Everything about what was done to him is in the federal record. Everything except whether it was right. That question was never put to the ledger. It was never put to any proceeding. It is still waiting in the archive, in a ruled column, in the deputy warden's careful hand, for someone with federal authority to read it and say what it means.